So, hello, I hope you're all fine. Um, there were several topics that we had not finished, and given the circumstances we are at, and the fact that, of course, we are required to do exams, I thought it is necessary for us to finish and to use any forum that we can be able to finish those few topics that were remaining. Now, for today, I would wish us to go through the law of agency. So there are three contracts here that I would wish for us to finish. We have sale of goods, the law of agency, and we have hire purchase. Initially, I think the last thing we did was complete the law of contract. Now, we finished actually the general law of contract. So what was remaining is actually those specific contracts. And the specific contracts that are important for any students or business is the law of agency, sale of goods, and of course hire purchase. Now, sale of good is important because we are assuming that in one way or the other, as students of business, or so because procurement is part of business, you're required to know a bit of agency and a bit of sale of goods. So, like sale of goods, like I was about to say, sale of goods is important because every day we engage in transactions where you exchange goods in exchange for money. And so it is imperative then that we endeavor to understand deeply what the law of contract actually means. So the first thing I would want us to begin with is to be able to ask ourselves what is a contract of agency. And a contract of agency, of course, like the word suggests, is a contract between an agent and another party we refer to as a principal. In this nature of contract, normally, the principal normally appoints the agent, and the purpose of the agent is to transact on behalf of the principal with a third party. So what the principal does is to give authority to the agent for the agent to connect the principal in some sort of transaction. At the end of the day, the transaction becomes binding upon the third party and the principal. So the agent gets out of that transaction. And the bigger picture is actually not liable. So generally, the agent never is liable personally for such contracts. It's actually the principal and the third party. So ideally, therefore, there are three parties in a contract of agency. You have the agent, you have the principal, and you have the third party. So the work of the agent is to transact on behalf of the principal with the third party. So, if, for example, I have hired Amos to purchase for me 100 bags of wheat from a farmer in Eldoret. Now, the work of this agent, because I've given him authority to act on my behalf, is to look for a farmer who can be able to sell me the wheat that I want. So, at the end of the day, it is not him, it is not Amos who pays for the wheat. It is actually I, the principal, that has authorized him to transact on my behalf, who becomes bound to actually pay for the wheat. Now, the other thing then therefore we ask ourselves, how do we create a contract of agency? And there are several ways in which a contract of agency comes into existence. Now, like, because it is a contract and every contract involves agreements, therefore the first way in which a contract can be brought into existence is by what we call express agreement. Express agreement is where a contract is created either by word of mouth or in writing. So the authority would therefore have been given either by word of mouth, by the principal to the agent, or in a written document. So therefore, the existence of a contract is to be found by words that were exchanged between the parties or words that were put into a written contract. Number two, the other way in which a contract would come into be this nature of contract would be by implied agreement. Now, implied agreement in terms of the law of agency occurs in scenarios where the principal does not give authority to the agent either through word of mouth or in writing. Generally, therefore, the contract of agency is presumed or implied from the circumstances of the case or from the way in which the conduct of the parties is or how the parties are conducting themselves. Now, generally, there are two ways in which a contract may be brought into being. An agency contract may be brought into being by implied agreement. One is by agency by estoppel. Now, agency by estoppel arises in scenarios where a person by his word or conduct has willingly led another to believe that certain set of facts exist or circumstances exist while they actually do not. And in such scenarios, he will be prevented from denying the existence of such circumstances, because by his conduct or by his words, he has led another party to believe that certain state of affairs or circumstances exist, even if those circumstances do not actually exist. I'll give an illustration. For example, Pendo tells Amani in the presence and within the hearing of Nancy that she's Nancy's agent. Nancy does not contradict this statement and keeps quiet. Later on, Amani enters into a transaction with Pedro, believing honestly that she's Nancy's agent. Nancy is bound by this transaction, and she will be stopped, from denying the existence of agents. So here, the conduct of Nancy in this scenario is that she kept quiet when Pendo made allegations that she was acting actually on her behalf. She never contradicted Pedro by saying that she is actually not my agent. So as a result of her silence, Amani was led to believe that Pendo indeed is Nancy's agent. And that is how an agency by estoppel actually comes into being. Remember here, the agency is not established by either word of mouth or in writing. It is established by the conduct of the party here. The other way in which this nature of contract may come into being is by under the principle of holding out or agency by holding out. So in this scenario, it is where an agent has been held out by the principal as an agent. So for example, if Paul has hired Amos to sell his shop, and every month he has authorized him to take goods worth 100,000 from Mr. Shah's warehouse. And every month that happens, Paul always pays for the goods. So suppose then that Paul fired Amos 1 month ago, and then Paul does not inform or give notice to Mr. Shah that Amos no longer works for him. So again, perhaps Amos, for argument's sake, goes to the same shop, takes goods worth 100,000, does not tell Mr. Shah that he actually does not work for Paul anymore. Now, in this scenario, at the end of the day, Paul would still have to pay the 100,000. He had an obligation when the moment he fired Amos to inform Mr. Shah that had happened. So here, the Amos is an agent by holding out. Another way in which an agency comes to an end, into being, is by necessity. Necessity is a way in which an agency contract comes into being, where a person is faced with an emergency in which the property or interest of another are in imminent danger, and it becomes necessary in order to preserve the property or interest of that person to act before the instructions of the owner are obtained. So here, what would have happened is that some emergency situation has arisen. This person does not have authority from anyone, from the owner of the property to act on the interest of that person that are going to be interfered with as a result of those circumstances arising. But because to prevent that person from suffering injuries or damages either in business or in interest or even in property, he acts before he's given authority. Now, of course, for an individual to qualify as an agent of necessity, there are three conditions that must be met. One, there should be a real necessity for acting on behalf of this principle, which means there has to be an emergency situation that warrants this person to actually act on behalf of this other person. Two, it should be impossible to communicate with the principal within the time available. Now, the reason why this person is acting without authority is the fact that he's unable to communicate with the principal. If it is well within his diligence to be able to obtain instructions from the principal and he does not do that, then he cannot qualify as an agent of necessity. And as such, if he acts, then he can be held liable by the principal. But in scenarios where he has used all skills and diligence to be able to obtain instructions from the principal, and it has become impossible for him to do that, then he is, by all means and purposes, an agent of necessity. Then the final one is the alleged agent acted or should act bona fide or in good faith. It is imperative, it is important that for this individual to qualify as an agent of necessity, that he must indeed act in good faith. He must put himself into the shoes of a principal so that then he asks himself, if this interest were mine or if this property is mine, how would I have acted? And then act in the same way he would have if the property was his. Now, for example, if Amos has been hired to transport fish from Mombasa to Nairobi, and along the way the vehicle suffers some mechanical problems, and he decides to sell the fish in the place in which he is at, because he reasons that if he brings the fish into Nairobi, the fish would have gone bad given its perishable nature. Uh, then upon arriving, once he has sold those fish and upon arriving in Nairobi, suppose Paul refuses to pay him his commission. Now, the matter ended up in court. He'll be arguing that he's an agent of necessity. And at the end of the day, if he's able to prove those three things, he then qualifies as an agent of necessity, and he therefore would be entitled um, to his commission. Finally, an agency can come into being by ratification. Ratification means the subsequent adoption and acceptance of an act originally done without instructions or authority. In other words, ratification is a way in which an agency is created by the principal accepting or adopting an unauthorized transaction made by the agent. When an agent has acted without authority, the principal normally has two options: either to hold the agent personally liable or to ratify the transaction. So when he ratifies, what he's actually doing is to accept that transaction, and he becomes bound as if the agent had authority all along. And such, therefore, creates an agency by ratification. Now, of course, for a principal to be able to ratify a transaction or to create an agency by ratification, there are certain essentials for a valid ratification. One, the agent must purport to act as an agent for a principal, which means that in the mind of a third party, the third party must be aware that this person is merely acting as an agent on behalf of another person. So if the agent goes and is claiming to be the third party, then the principal cannot ratify that, because the third party is transacting with the agent, thinking that he's actually the other party to the transaction. So that means it is very, very important that the agent informs the third party that is merely acting as an agent. And that is one of the first essentials of ratification. Two, there should be an act capable of ratification. What that means is that the principal cannot ratify a transaction that is illegal or unlawful. Three, the principal must have been in existence at the time to which the transaction was done. And this happens especially in company law. Companies cannot accept transactions that were formed or entered into before the formation or before the incorporation of the company. So that is very, very important, that the principal must have been in existence at the time of entering into the contract. Now, four, the principal must be competent to contract. Competence to contract means the ability of the principal to be able to engage in a contract. And that would arise because either he has the necessary mental capacity to do so and is within the age limit which he can be able to transact. Then five, the principal must have full knowledge of material facts. Now, having full knowledge of material facts means that before the principal can be able to ratify the transaction, he must know everything about that transaction. He cannot ratify that which is not within his knowledge. So he must only ratify that which is well within his knowledge. And then six, he must ratify the whole transaction, which means he cannot accept some of the benefits of the transaction and refuse the obligation of the other parts of the transaction. So he must ratify the whole transaction. And then the ratification must be done within a reasonable time. And what is reasonable is determined by the circumstances of the case, as well as the time to which the original transaction was supposed to be performed. And then finally, ratification must not injure third parties. So by accepting the transaction, it will have the consequences of interfering with the interest of a third party. Then the principal must not ratify that particular transaction. Which brings us to the ways in which you can classify an agent. An agent can be classified either generally by the authority the agent has and by the nature of the work. So according to the extent of the authority that the agent has, the first way in which you classify the agent is that one is by being that is a general agent. A general agent is an agent who is employed to do all acts that are connected with a particular business or employment or even trade of the principal. So if the principal is a hotelier or a hotel owner, and he has hired an agent as the manager of the hotel, then the principal can be bound by the manager, in this case the agent, in all acts that are connected with the business of that hotel. So which means that he can hire and fire employees within the hotel. He can buy supplies for the hotel and all that, but he cannot buy furniture for the purposes of reselling the furniture because that is not in the nature of hotel business. So the general agent He can only bind the principal if the acts that he's doing are connected with the business of that particular principal. Now, then we also have a special agent, number two. A special agent is an agent who's employed to do some particular act or to represent a principal in a particular transaction. It's like, for example, Paul wants to buy a piece of land somewhere in Kajiado, and he has hired Amos to seek out a seller of the same. Now, the moment the transaction is done, then the agency comes to an end because the appointment of the agent, in this case Amos, was merely to just do that particular transaction. And once that particular transaction or act is done, and the agency comes to an end. Number three, you also have a universal agent. A universal agent is an agent who is appointed to do all acts that the principal can do and actually delegate. So any act that a principal can do and actually delegate, then the agent can actually do. Now, of course, there are things that the principal cannot delegate, like an agent marrying on behalf of the principal, because that is not something you can delegate. But every act that is to be can be done by the principal, and that which he can also delegate, then the agent can also act. But it is important to note that a universal agent is a very powerful agent. In this kind of agencies are very rare. Now, for you to be able to engage in a universal agent, you are required to have a power of attorney, which then donates the power to the agent to act on behalf of the principal. Then you have number four, sorry, a broker. A broker is an agent who is hired to represent either the buyer or the seller to be able to negotiate a reasonable price for either the buyer or the seller without having the physical contact of the goods. So he never has the physical contact of the goods, or he never physically handles the goods. His job is just uh, to negotiate the best possible price on behalf of either the seller or the buyer. So if he's acting on behalf of a seller, is to get the highest possible price. If he's acting on behalf of a buyer, it is to negotiate the least possible price. And at the end of the day, of course, he gets a commission known as a brokerage. Then we also have a factor, is a way in which also you classify an agent. A factor is an agent who is hired to sell goods in his possession on behalf of the principal. So unlike the broker, this one sells the goods that are in his possession at the end of the day, and he can even give goods on credit on behalf of the principal. Then we have a commission agent. This is a person who is employed to buy or sell goods for the principal at the best possible price. That is what we refer to as a commission agent. Then we also have a direct agent, one who is employed to sell the goods on the behalf of the principal, and he gives an undertaking or a promise to the principal that in the event that the third party does not pay the price of the goods, he will stand in the place of the third party and actually pay for the goods. And then we have a forwarding agent, and forwarding agents are agents that are appointed to act either on behalf of exporters or importers. And then finally we have an auctioneer, and an auctioneer is an agent who is employed to sell goods in an open auction, an open auction. And those are ways in which you classify agents. Now, which brings us to the duties and the rights of these parties. Now, the duties of an agent, the first duty that the agent has is a duty to follow the principal's directions or customs. He must act within the provisions of authority given. If he acts outside the premise of that authority, then he can be held personally liable. Number two, he has a duty to carry out the work that he has been given with reasonable skills and diligence. So he must conduct the business of the agency with as much skills as is generally possessed by individuals that are engaged in similar businesses. So if he's an accountant, he must portray the skills required of an accountant. Number three, he has a duty to render accounts, which is a duty of the agent to keep proper principles record in terms of money or even property, and to render such periodically or when the principal has requested to have such records or accounts. He also has a duty to communicate, and especially in emergency situations, he has a duty to use all diligence to be able to obtain instructions from the principal before he acts in such emergency situations. Only then can he act if, for example, he's not able to get the communications he desires. And then he has a duty not to deal on his own account. An agent must not deal in his own account, which basically means he must not sell or buy from the principal without the authority of the principal. You know that. Then he has a duty not to make any secret profits of the agency transaction. So he must not make any secret profits. If he sells goods that he's selling at a profit, those profits do not belong to him; they belong to the principal. Then he must render those particular profits to the principal. Then finally, he has a duty not to delegate authority. Now, when he's given authority to act, he himself must be the one that acts. He must not delegate that authority. But of course, there are scenarios where an agent can be able to delegate authority. One is where the principal has expressly or impliedly permitted the delegation. Then, where the ordinary customs of trade, a sub-agent may be employed, or where the nature of agency makes it necessary to appoint a sub-agent. For example, a manager of a shop may require a sales assistant to help him. Where the acts to be done are purely clerical, they do not require a lot of skills, they are merely clerical. And during unforeseen circumstances of emergency, then he can delegate authority or power. Then we have the rights of an agent. One is that he has a right to receive remuneration, of course, that goes without saying. Two, the right of retainer. So an agent has a right to retain out of any sums received on account of the principal or money due to himself in respect of his remuneration, which means that if the principal has not paid him his dues or has not remunerated him, and he as an agent has received money while doing or transacting on behalf of the principal, and the money belongs to the principal, he can retain, or he has a right to retain that money on the basis of the fact that the principal has failed to actually pay his remuneration. We call that the right of lien. I mean, the right of retainer. The right of lien is another right that the agent has. And the right of lien is the right that the agent has to keep any assets or property that he has that are in his hands in respect to any money that the principal owes him, and then hand the property or even the documents to the principal that once the principal has paid him his dues. And then you also have a right to be indemnified. So if the agent has used his money in transacting on behalf of the principal, he has a right to receive his money back. And that is what the right of indemnification means, or the right of indemnity. Then finally, we have the right to be compensated. So if the agent has suffered any losses or injuries as a result of the negligence of the principal, he has a right to be compensated. So in summary, the agent has uh, a duty to follow the principal's instructions or customs, a duty to carry out the work with reasonable skills and diligence, a duty to render accounts, a duty to communicate, duty not to deal in his own account, duty not to make any secret profits, and duty not to delegate authority. The agent also has certain rights. One, he has a right to receive remuneration, he has a right of retainer, he has a right of lien, and he has a right to be indemnified, and he has a right to be compensated. Those are the rights that the agent has. Now, if you look at those rights, you'll find the rights of an agent are actually the duties of the principal. So the principal would have the duty to remunerate the agent, to compensate the agent, and to indemnify the agent. But the duties that the agent has become the rights that the principal has. For example, you would have a right uh, to 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 fire the agent if the agent has made any secret profits, or he would have a right to receive communication in emergency situations. He has a right to expect that the work shall be done with reasonable skills and diligence. He also has a right to an account of his money or his property, among others. So I wanted to read some more so that we can be able to identify those rights that the principal has. Now, of course, now generally it's also important to note that in the law of agency, the agent is not personally liable. Normally, he's not personally liable. at the end of the day, it is actually the principal and the third party that are actually liable within the agency contract. However, there are scenarios where the agent becomes personally liable, and it is important for us to be able to understand those circumstances under which the agent may be held personally liable. One, where the agent has expressly or impliedly agreed to be held personally liable, where the contract is for the sale or purchase of goods for a trader that is residing abroad. Number four, where the agent acts for an unnamed principal, or the other one is where an agent is acting for an undisclosed principal, where the other one is where an agent acts for a principal who cannot be sued, like an ambassador or a head of state or even a minor. So he becomes liable should something go wrong. The other one is where the agent exceeds his authority, and the other one is where there is a trade usage or custom, whereby the agent incurs personal liability, and then where the agency is coupled with interest and all that. So those are circumstances under which the agent becomes personally liable. Now, which brings us to termination of a contract of agency. So, of course, a contract of agency may come to an end either generally by the act of the parties, and number two, by operation of law. Now, of course, there are three ways in which a contract may be brought to an end by the parties themselves. One is by agreement. Of course, it's a contract, which means that it can be created through agreement. It can also be terminated through agreement. Two, by revocation of the principal. So the principal may revoke the agency. Revocation here means that he may withdraw the authority he has given to the agent. And once he has withdrawn, then the agency comes to an end. Then the agency may also be terminated by the renunciation of the agent. Now, the renunciation of agents actually means that generally that the agent cannot be compelled to continue acting as an agent. He may decide to renounce the agency, and while he may decide to renounce the agency, he is required, if that is what he seeks, to be able to give notice to the principal that his intention is to terminate the agency. Then the agency may also be brought to an end by operation of law. What that means is that the agent may be brought to an end but when we say by operation of law, that actually means automatically by the happening of a certain event. So it could be number one, an agency may be brought to an end by operation of law. Number one, expiration of time. So if the agency was supposed to be within a particular period of time, and that time has come to an end, and the agency comes to an end. Two, completion of the business of the agency. So if the business of agency was supposed to be within a specified period of time and that has ended, and that, or I mean, sorry, it was supposed to be a particular specific transactions or act, and that act has been done, then the agency comes to an end. Death of the principal of the agent, that is another way in which an agency will be brought to an end by operation of law. Four, insanity of the principal of the agent. Five, destruction of the subject matter. So if the contract was the subject matter was a building where Amos was the agent, and the building is damaged by fire or an earthquake, of course the contract is basically based on that particular building, and so because it has been damaged, of course the contract comes to an end. And then of course if a company was a principal or an agent and the company has been dissolved, the agency comes to an end as a result of that dissolution of the company. And then, of course, bankruptcy of the principal terminates the agency. And then, of course, if the principal and the agent becomes alien enemies, then the agency comes to an end as a result. Now, companies become, sorry, individuals become alien enemies in these scenarios when countries have gone to war. If Kenya and Somalia went to war, the principal was a Kenyan while the agent was a Somalian. Because the two have become alien enemies because those two countries are at war, automatically that contract comes to an end. In summary, therefore, an agency comes to an end by operation of law. Number one, by expiration of time. Two, completion of the business of the agency. Three, by the death of the principal of the agent. Four, insanity of either the principal or the agent. Five, destruction of the subject matter. 6, dissolution of a company. 8, where the principal and the agent becomes alien enemies. And finally, number 9, bankruptcy of the principal. So that indeed is the law of contract. The law of contract of agents. And I would wish for you to listen and read more. Watch the video and also read more on the handouts that I had sent, or the notes that I had sent, so that then you'll be able to understand deeply on the topic on agency. And I hope you can be able to answer problem type questions based on the law of Estopel. And I want you to read more on the law of Estopel and the principle of holding out, so that then you can be able to answer problem type questions based on that and necessity in terms of agency. Because of course, questions on agency, given the nature of the law of agency, there are certain questions that may be brought as a problem type question as opposed to having to answer them in any other form. So read that deeply and ask yourself questions on Estopel, so that then you'll be able to understand. So read more on the law of Estopel so that you'll be able to answer such questions. Now I hope that is well understood. So then